Thank you so much, Daron, and thank you all for participating here. And I thank and I'm inspired by all of the speakers here today. I'm going to divert a little bit and say a quick Dvar Torah after listening to the inspiring words of Rav Moshe Soloveitchik. I think you knew my father-in-law, and a few weeks ago was my father-in-law's yahrzeit, and it fell out on the parsha dealing with the pasuk of the mitzvah of building a makah lagagecha for a bayis chadash, of building a guardrail for a building that has a flat roof. And when I heard Rav Moshe speak about making laws that prevent these types of crimes, not to contribute to a hospital, but that we should build and reinforce the bridge, I immediately thought of that vort. It was really quite inspiring. Listening to Vivian, our psychologist, she addressed the profile of a pedophile. And in wrapping up here today, I'd like to get into the why question. Why has it taken so long? And perhaps if we understand the why, perhaps I can take off my hat as a legal practitioner. I've been practicing law for some 20, 25 years. I'm a trial lawyer. I've tried cases before juries. I'm also an appellate lawyer. I've argued many appellate cases in appellate courts in the state and federal courts in New York. I'm going to be a legal philosopher for the next few minutes. I've handled child sex abuse cases. I've handled adult sex abuse cases. And quite frankly, sometimes I have the reputation of being a pretty tough guy lawyer. In New York, the lawyers have sharp elbows. And it's only the sex abuse cases which really grip me. And even at times have forced me to tears. The accounts that I heard from Mark Weiss and from Penny Taub were so absolutely gripping. And Dr. Asher Lipner talked about what's called vicarious trauma. All of us are sustaining some type of vicarious trauma today in listening to these accounts. But the question that I'd like to put before you and for the next few minutes is to address why. Why has it taken our community, other faith communities, so long? And have we deviated a little bit from the American ideal? I'm going to take you back only about 2,000 years, and I'm going to cover this 2,000 years in the next 10 to 15 minutes. We start in the 3rd century, shortly after the beginning of the Common Era, and we continue from the 3rd century until about the 11th century. And it seems that in Catholic England, there were two ancient common law doctrines, something called benefit of the clergy and something called sanctuary. Now, if you were a priest and you committed a crime such as a rape or stealing something, you wouldn't be adjudicated in the king's courts, the royal courts. You would be adjudicated in the ecclesiastic courts, and that's called benefit of the clergy. Now, if a priest committed a felony, or if anybody committed a felony in common law England, all felonies automatically received the death penalty. You would be hanged, or your head would be chopped off, whatever they did back then. So it was really advantageous to become a priest and to get this legal doctrine of benefit of the clergy. In addition, there was another common law, another doctrine of something called sanctuary. If you were a criminal and you ran into a church and you would seek the protection of the church, the type of penalty you would receive for that crime would be far less than if you were, again, adjudicated in the royal courts. So you had these two parallel court systems. You had the royal courts and you had the ecclesiastic courts. And you had, of course, the opportunity for corruption. This situation lasted from the 3rd century until about the 11th century, and there was a king whose name was King Henry II. And he was a good king, and he saw that things should be reformed. And he wanted to eliminate, to some extent, whatever it was. I'm not a professional historian. As I said, I am a legal practitioner. To some extent, he wanted to eliminate this terrible situation. And we had these basically corrupt ecclesiastic courts. So he contacted the Archbishop of Canterbury, a man named Becket. And Becket said yes. But there was some opposition to that, and Becket was pressured. Anyway, there was a situation where Becket ran to France, and the king spoke out against him, and Becket came back. Some of the king's supporters got a little bit carried away, and the supporters of King Henry II murdered Becket. Right now, there is a wonderful group in the United States called the Becket Foundation, the Becket Society, I don't recall the exact name, and they fight for religious rights. Anyway, King Henry II's program of seeking reform was somewhat set back, and but they remembered it. And then about 300-400 years later, sometime in the 1500s, the Parliament got involved, and the Parliament did away with this parallel system of having serious felonies, of having serious criminal felonies tried in the ecclesiastic courts, and everything was brought under the royal courts. Now, at around the same time, you had the system of inquisitions, and the Catholics and the Protestants were fighting in England. Queen Mary was Catholic, Queen Elizabeth was Protestant. Queen Mary killed a lot of Protestants, Queen Elizabeth killed a lot of Catholics. For those of us who have visited London, perhaps you saw the Tower of London, and there was a tremendous amount of executions there, both by fire and by hanging, and it was a terrible thing. It was around this time, as I said, there were inquisitions. So there was an inquisition in Spain. The inquisition in Spain concerned the Marranos, the Spanish inquisitors. Torquemada, he wanted to find out, who was a secret Jew, and there were inquisitions going on in France and Germany and other countries as to who was secretly practicing their religions. There was so much religious oppression, people started moving to America, the land of the free and the home of the brave. And of course, Columbus, as we all know, left in 1492, around the time that the Inquisition there began. And the thesis, by the way, that is put forth by Professor Marcy Hamilton, a law professor at Yeshiva University's Cardozo Law School, is that when the framers of the U.S. Constitution actually wrote the Constitution, particularly James Madison and Thomas Jefferson, they had this whole history of church abuse in mind, and they wanted to stop that. So we have a First Amendment that has an establishment clause, and I quote it almost verbatim: "The government shall make no law respecting an establishment of religion." Some of the early framers were deists. They were totally against organized religion. They just believed in God, and they were against organized religion. In particular, Thomas Paine was a deist. Thomas Paine, of course, was the author of the pamphlet Common Sense, which was distributed throughout the colonies and persuaded the early colonialists to rebel against England and to form our own nation. And Thomas Paine wrote this pamphlet, as I said, Common Sense, and he quotes the Sefer Shmuel, the book of Samuel. And in the book of Samuel, the Jews ask to have a king. And Samuel says, no, 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 you don't want to have a king. And the Jews say, yeah, we want to have a king just like the other nations. So kings are frowned upon in Jewish tradition. And the reason why Thomas Paine wrote that is because they were so anti-king. They were so anti the class divisions and the persecutions that they had suffered in England that they knew about from elsewhere in Europe.